I didn't go to work that night thinking about death. I went thinking about rent. About the pink eviction notice folded inside my locker, creased down the middle where I'd folded it so nobody could read what it said even if they looked directly at it. About my son's inhaler that had maybe 3 days left in it, and a refill that was going to cost $94 we did not have. About the way my daughter had started pretending not to notice when we had cereal for dinner, the particular way kids do when they have decided, on their own, without being asked, to protect their parents from the worry they can already see on their faces. She was 9 years old, and she was already carrying things she should not have been carrying. I thought about her every single night on the drive to that plant. 16 years at that factory. 16 years breathing metal dust. 16 years of night shifts, of punching that clock in the dark and punching it again in the dark on the way out, of watching my life move around me like something happening to someone slightly to my left. 16 years of believing. The way you believe something when you have no better option, when belief is less a conviction and more a survival strategy. That if I kept my head down, if I did my job, if I didn't ask the wrong questions or say the wrong things or look too long at the things that didn't add up, I would be safe. That my family would be safe. That the institution I showed up for every night had some interest in my continued existence beyond what I could produce between the hours of 11 and 7. I was wrong about that. And I want to be careful about the way I say that, because it would be easy to make it sound like naivety, like I was a simple man who didn't understand the world. I understood the world. I understood it the way anyone who has worked inside a large industrial machine for 16 years understands it. Not from books, not from business school, but from the floor. From watching what happened to people who spoke up and what happened to people who stayed quiet. From learning, early and conclusively, which version of those two outcomes the company preferred. What I didn't understand, what it took everything I had to finally accept, was that the system wasn't failing. It was succeeding. It was doing exactly what it had been built to do. And by the time I understood that, 2 of my co-workers were in an ambulance and the company's lawyers were already in a conference room deciding what the story was going to say. My name is Caelum Harte. I was a maintenance and compliance technician at a regional processing facility in Licking County, Ohio, called the Hartwell processing plant. I had been there since I was 31 years old. I was 47 on the night the floor broke open. 47 years old, with a son in community college, a daughter in the 4th grade, an eviction notice in my locker, and 16 years of institutional loyalty in my body like sediment, like something that had accumulated so slowly I had stopped noticing its weight. That night, I walked into the plant the same way I had walked in for 16 years. Badge swipe, clock punch, coffee from the machine in the break room that always tasted like the cup had been sitting since the previous shift. Locker, hard hat, the specific smell of a facility that never stops running, oil and metal, and the particular chemical tang of whatever they were processing that week. I did my walkthrough. I checked my assigned sections. And I checked line 7, because line 7 was the thing that had been sitting at the back of my mind for 4 months, and some part of me already knew that it was not going to stay at the back for very much longer. The machine sounded wrong. That is the only way I know how to say it. Not broken, wrong. There is a difference, and if you have worked around heavy industrial equipment long enough, the difference becomes something you feel in your chest before your brain has processed it. Broken is immediate. Broken is a sound that stops everything. Wrong is subtler. It is a frequency that sits slightly off from where it should be, a vibration pattern that does not match the one you have memorized through years of standing next to the same equipment. Wrong is the machine telling you, in the only language it has, that something inside it is under stress it was not designed to carry. I stood next to line 7 for 3 minutes that night, listening. I went to the monitoring panel. Every gauge was green. Every indicator said normal. I made a note in my personal log, not the company log, my own, and I started my shift. I have thought about those 3 minutes many times since. The compression assembly on line 7 failed at 3:47 in the morning on March 14th. The official incident report, filed by the company 3 days later, would describe it as a sudden mechanical failure resulting from equipment reaching the end of its service life in a manner that could not have been predicted. That sentence is one of the most precise pieces of dishonesty I have ever read. Every single word of it is technically defensible. Assembled together, they constitute a lie. What happened to that assembly was not sudden. It had not reached the end of its service life in any meaning of that phrase that would satisfy a reasonable engineer. And it had been predicted, in writing, in detail, with dates and location codes attached, multiple times, by multiple workers, over the course of more than a year. The company had those predictions in its own internal system. Every single one of them had been marked resolved. The machines were screaming louder than usual that night, and they had been screaming for months before it. The only people who needed to listen had a quota to hit, and they had already decided that listening was a cost they were not willing to absorb. Before we go further into what happened on that floor, I want to tell you something that every person who has ever worked inside a large industrial facility already understands, and that almost no one outside those walls ever hears. In places like that, safety is a performance, not a value, not a genuine operating principle, not the thing the posters on the break room wall say it is. A performance. There are boards with green numbers showing days since last incident. There are laminated cards with the OSHA hotline number. There are mandatory trainings where a supervisor reads slides off a projector in a conference room, and everyone signs their name on the attendance sheet. And then the training ends, and everyone goes back to the floor, and the gap between what was on those slides and what is actually happening out there, between the official version and the floor version, is so wide and so consistent and so deliberately maintained that after a while, you stop being surprised by it. You just learn which version is safe to believe in out loud, and you keep the other one to yourself. Before we go any further into this story, and we are going to go deep, let us know in the comments where you are watching from. We would love to hear from you, and if this story is hitting close to home, if you have seen something in a workplace that looked like what I am describing, drop that in the comments too. We read them. And don't forget to hit that subscribe button so you never miss any of our upcoming videos. Now, back to Caelum Harte and what he found inside the Hartwell processing plant. Because what started as one man paying close attention to numbers that did not add up became something that exposed a pattern of corporate safety suppression that had been operating uninterrupted and unpunished across multiple facilities and multiple states for years. This is not a story about one bad night. This is a story about a system, and about what it takes to bring one down. There are three people at the center of what happened at Hartwell. The first is Caelum Harte, the maintenance and compliance technician who saw what was happening, documented it, and refused to let it stay buried. The second is Raymond Colt, the regional operations director, the man who sat at the top of the decision-making chain at Hartwell and who, as Caelum would eventually be able to prove, knew precisely what was happening on that floor and what the risk was and signed off on continuing anyway. And the third is Dale Ferris, the plant manager, the man who ran the day-to-day operation, whose fingerprints were on every safety log, every incident form, every complaint resolution that came back stamped closed before a single thing had been fixed. Three men in a system that had been designed, carefully and deliberately, to make sure that what was happening inside that plant stayed inside that plant. And one man who, on the morning of March 14th, decided that was no longer acceptable. Here is what the records show, the ones that were eventually recovered and authenticated during the federal investigation. In the 14 months before the incident on March 14th, 41 separate safety concerns were filed through the Hartwell facility's internal reporting system by workers on the floor. 41 individual people, or groups of people, seeing something wrong and doing exactly what they were told to do, reporting it through the proper channel. Every single one of those 41 concerns was marked resolved within 72 hours. Not addressed, resolved. There is a difference. A later independent review of those records, conducted as part of the federal investigation, found that 26 of those 41 closures had no documented corrective action of any kind. The checkbox was checked. The problem remained. The machine kept running. And the people who ran Hartwell knew that this was the outcome, because they were the ones marking the boxes. The Hartwell processing plant had been operating for more than 20 years when Caelum Harte started paying close attention to the numbers in the fall before the incident. It sat on 40 acres of industrial land in Licking County, Ohio, processing and packaging materials for a supply chain that fed into manufacturing operations across the Midwest. At peak capacity, it employed just under 400 people. The wages were good by the standards of the surrounding region. The work was steady. The benefits were real. In that part of central Ohio, in the kind of towns that ring Columbus without quite being Columbus, a job at Hartwell was the kind of job people held on to. The kind of job you told your kids about if they needed to understand why you couldn't make it to the school play. The kind of job that becomes, over enough years, less a place you work and more a fact of your life. Something as fixed and assumed as the mortgage and the commute and the specific ache in your lower back that never fully goes away. Raymond Colt had been the regional operations director for 7 years. He was what people in that industry call a results man, and not in the soft, everything is results sense. In the specific sense of a man who was very good at hitting targets and very clear, in his own operational philosophy, about what had to be true for targets to be hit consistently. Under his tenure, the Hartwell facility consistently ranked in the top tier of output among the company's regional sites. The quarterly presentations were clean. The bonuses were good. The numbers, every quarter, were what they needed to be. Raymond Colt understood something that a certain kind of operations executive always understands, that there is a precise calibration between what you push and what you let slide, and that getting that calibration right is the skill that separates the people who keep their jobs from the people who do not. He had been getting it right for 7 years. Nobody above him had any particular reason to ask what the calibration cost. Dale Ferris ran the day-to-day. He had come up from the floor himself, which gave him a specific kind of authority. The authority of someone who could speak the language of the workers because he had been one, and who used that fluency to project an approachability that made the workers trust him slightly more than was wise. You could talk to Dale Ferris. He knew every shift supervisor by name. He showed up on the floor during production runs. He remembered birthdays. He was, in all the surface ways, a decent manager. But the workers who had been at Hartwell long enough knew the truth, which was that talking to Dale Ferris about something real, something that mattered, something that wasn't going to resolve itself, had a specific and consistent outcome. The conversation happened. It was cordial, and then nothing changed. And if you came back a second time, you started to notice that the conversation was slightly less cordial. And if you came back a third time, you started to notice other things changing too. Most people figured out the pattern after the second time. A few of them kept trying anyway. Caelum Harte was one of those people. The worry had been building on that floor for months before March 14th. Not in any organized way, not in any way that had a name or a plan attached to it, but in the specific, ambient, spreading way that worry moves through a workforce that knows something is wrong and has already figured out that the official channels for saying so go nowhere. The pressure irregularities in Line 7 had been reported 3 separate times in the 6 months before the incident. Each time, the report was logged in the internal system. Each time, a resolution came back within 48 hours. Inspected, within acceptable parameters. Each time, the workers who actually ran that machine, the ones who stood next to it for 8 to 12 hours a shift and knew its sounds and rhythms the way you know the sounds of your own house at night, went back to work knowing that whatever had been done was not the thing that needed to be done. They knew it. And they also knew, by that point, that knowing it was not going to change anything. A senior technician named Gretchen Hollis had submitted a formal written request for a mandatory equipment review on Line 7 back in October. The request was detailed. It referenced specific pressure readings, specific dates, specific service intervals. It was the kind of request that, in a facility that actually operated the way the training slide said facilities operated, would have triggered an immediate review and a documented response from engineering. Instead, it was rejected 4 days after submission on the grounds that it duplicated a prior concern that had already been addressed. The prior concern it was said to duplicate was the first of the 3 pressure irregularity reports, the one that had been marked resolved after a 2-line inspection note. Gretchen Hollis told Caelum about this in the break room one evening in November, sitting across from him with a cup of coffee and the flat, tired expression of someone who has been very clear about a problem and very deliberately not heard. She said, "I put it in writing again and they closed it again and I don't know what else to do." And Caelum told her what he always told people who came to him with things like this, because he still believed it at that point. Try one more time, document everything, go through the right channels. He said that to her 6 weeks before March 14th. He has thought about that conversation many, many times since. The maintenance schedule for Line 7's primary compression assembly had been extended beyond the manufacturer's recommended service interval in September, 3 months before the incident. The manufacturer's specification was a full service at every 18 months of continuous operation. By the morning of March 14th, the assembly had been running for 27 months since its last full service. The extension had been logged internally as an operational decision pending equipment availability. The specific equipment needed for the service was listed as on order. In actuality, the order had been placed, delayed, and then quietly deprioritized in the company's procurement system in favor of components for a different line that was under a more immediate production deadline. The workers on Line 7 knew the service was overdue. The shift supervisors knew it. Dale Ferris knew it. There is documentary evidence, recovered during the federal investigation, that Raymond Colt had been informed of the delay in writing and had approved the continued operation of the assembly pending resolution. He approved it in September. The assembly failed in March. The workers standing near it when it failed were Terrence Banks and Philip Darden, 2 men who had nothing to do with any of those decisions and no knowledge of them and no power to change them. They just showed up for their shift. Caelum Harte grew up in Columbus, Ohio, the youngest of 4 children in a family that understood work the way families who have had to fight for it understand work, as something that carries a dignity that people who have never needed it sometimes fail to recognize. His father spent 30 years on the floor of a manufacturing plant in the Whitehall neighborhood of Columbus and retired with a back injury that had been quietly worsening since his mid-40s, the kind of slow accumulating damage that doesn't show up in the incident log because nobody ever fell down. Nobody ever needed an ambulance. The body just erodes over years of labor in a way that looks, on paper, like aging. His mother worked 2 jobs through most of Caelum's childhood, hospital laundry and home health care, and she did both without complaint, in the particular way of people who have decided that complaint is a category of action they simply cannot afford. Caelum understood, from the beginning, what kind of life he was living. He did not romanticize it. He did not resent it. He showed up for it. He started at Hartwell in 2006, when his son Darius was 2 years old and his daughter Camille was still a year from being born. He started in general maintenance and moved into the compliance technician role in his 4th year. After the company restructured its internal safety documentation team and found, in the process of figuring out who was good at what, that Caelum was the person who caught the most errors in the paperwork. That is how he thought of the work, catching errors. He had a kind of pattern recognition that had been noted in every performance review he had received for 12 years. The ability to look at a record and feel something off about it before he could articulate exactly what the wrongness was. A number that didn't match. A date that was inconsistent with the sequence around it. A resolution that was logged faster than the problem it claimed to have resolved could physically have been addressed. He was good at finding these things. He was valued for it, right up until the moment when what he was finding was too inconvenient to value. His role gave him access that most floor workers at Hartwell did not have. He could pull maintenance logs, safety incident forms, equipment service records, and inspection reports across his assigned sections. Not unlimited access. There were levels of the documentation system that were restricted to management and above, but enough. Enough to cross-reference. Enough to see patterns across time. Enough to notice, in the fall of the year before the incident, that something in the data did not line up with what he was seeing and hearing on the floor. Not one thing. A series of small things, each of which had a plausible individual explanation, which together, when you looked at them in sequence, produced a picture that had no innocent interpretation. He started with the service record. In August, he had been on shift on a day when the maintenance log recorded a service visit to Line 7's secondary pressure relief valve. He was the on-shift compliance technician that day. He did not recall the visit occurring. He checked the sign-in log for the service bay. The technician named on the service record had not signed in on that date. He flagged it, a 2-line internal note to Dale Ferris, careful and factual, no accusation, just a discrepancy that needed clarification. Ferris responded within a day. The record had been reviewed and was accurate. Caelum marked it as received and let it go. He had a quota to hit. He had an eviction notice that was not yet pink. And one discrepancy, on its own, really could be a logging error. He was not looking for a fight. He was never looking for a fight. The second thing came in October. A pressure reading on Line 7's monitoring system showed a spike that, according to the facility's own safety protocol, should have automatically triggered an alert in the safety log and required a documented response from the on-shift compliance technician. Caelum was that technician. He saw the reading. He noted the value. He went to log it. He was told by the shift supervisor, before he could complete the entry, that Ferris had already reviewed the reading remotely and had determined it was within parameters. Caelum logged his own note anyway, the way he always did when something fell off, because documentation was not just his job. It was the reflex of a man who had spent 12 years finding errors. 3 weeks later, reviewing the log entries from that period, he found that his note had been edited. Not deleted, edited. The pressure spike value that he had recorded had been changed to a different number, a number that fell just inside the facility's acceptable range. His initials were still attached to the entry, but the number was not the number he had written. He sat with that for a long time. A change number in a compliance log can mean legitimate things: a calibration correction, a system timestamp adjustment, a supervisor override with documented justification. He went through every legitimate explanation he could think of and wrote them down on a piece of paper, which he kept in his car and not his locker, which was not an accident. And then he wrote down what was left when you eliminated every explanation that required someone to have acted in good faith. He kept that paper. He kept everything from that point forward. Not because he had decided what he was going to do with it yet, but because he was a man whose professional instinct, when he found something wrong, was to document it. He was doing what he had always done. The difference was that this time, the wrongness he was finding was not a clerical error. He filed a formal concern through the internal reporting system in early November. He was precise with the language, factual, specific, unemotional, the kind of submission that is impossible to dismiss on grounds of vagueness. He referenced the August service record discrepancy, the October log modification, and a third irregularity he had identified in the interval between the two: a safety inspection form for a section of Line 7's feed mechanism that had been signed off by a technician who, according to the shift schedule, had not been on site the day the form was dated. He attached his own records. He submitted the concern and received the automated acknowledgement. 8 days later, the concern was resolved, reviewed, and found consistent with normal operational variance. No corrective action required. The reviewer, Dale Ferris. Caelum filed a follow-up in December, more detailed, with additional documentation. It was closed in 4 days. Same conclusion. Same reviewer. He requested a meeting. The meeting happened in January, in Ferris's office, with the door closed. Ferris was patient, thorough, and fully impenetrable. He had an answer for every point. He thanked Caelum for his diligence. He made it clear, without saying it, without putting anything in writing, without doing anything that could be held against him, that this was over and that continuing to push it would be unwise. Caelum walked out of that office knowing something he had been trying not to know for 3 months. The system was not failing. It was working. Someone had built it to produce exactly this outcome. And the question was no longer whether something was wrong. The question was what he was going to do about it. March 14th started the way every night shift started at Hartwell. The parking lot filled up in the dark. Badges swiped. Clocks punched. The overhead lights hummed into their working temperature. Coffee from the breakroom machine. The particular smell, oil, metal, the chemical tang of whatever was running on the lines that week. Caelum came on at 11. He did his walkthrough. He checked line 7 and stood next to it for 3 minutes listening to the frequency that was slightly wrong and noted it in his personal log and started his shift. At 3:47 in the morning, the primary compression assembly on line 7 failed. The failure sent shrapnel across a 12-foot radius of the production floor. 2 workers were inside that radius. Terrence Banks, a father of 3 from Pataskala who had been at Hartwell for 11 years, took the primary impact. He sustained injuries to his right arm and shoulder that would require 3 separate surgeries and would leave him with permanent limited mobility, the kind of limitation that does not show up as a single catastrophic loss, but as 1,000 small daily subtractions from a life. The second worker, A younger man named Philip Darden, who had been at the facility for 18 months, sustained a serious head laceration and was held for observation. Both men were taken by ambulance. The floor alarm went. The section was shut down. Caelum was 40 feet away when it happened. He heard it, the sound that is not the sound of something breaking in the normal sense, but the sound of something that has been under the wrong kind of pressure for too long, finally releasing all of it at once. He moved toward the scene, and in moving toward it, he saw two things. The first was Terrence Banks on the floor, which is something he has said he will not describe in detail because it belongs to Terrence and not to the story. The second was Dale Ferris. Ferris arrived on the floor within 4 minutes. He lived 15 minutes from the plant, and the alarm automatically paged supervisors. This was not unusual. What was unusual was what Ferris did when he got there. He did not go to the injured workers. He did not go to the medical response team. He went to the monitoring station. He stood at the panel for approximately 2 minutes, looking at the system readouts. Then he took out his phone and made a call. And then he walked, not ran, walked, with the specific, deliberate pace of a man who has decided exactly where he is going, toward the records room at the back of the facility. Caelum watched him push open the records room door and pull it shut behind him. And Caelum made a decision in that moment that he has described as the clearest decision he has ever made in his life. He turned around, walked back to his station, and started pulling his own documents. What Caelum took from that facility in the hours immediately following the incident were copies of the records he had been keeping in his parallel log, the printed versions of the flagged maintenance entries, the notes he had written to himself about each discrepancy, the documentation of the complaint he had filed, and the responses he had received. He had kept physical copies in his car and in a folder at home for exactly this reason, because he had understood since October that the digital versions might not survive contact with the people who controlled the system they lived in. He was right about that. The federal investigation would later establish, through forensic analysis, that within the 4-hour window following the incident, 3 files in the Hartwell safety management system were accessed using Dale Ferris's login credentials. 2 of those files were modified. 1, the September complaint filed by Gretchen Hollis, the one that specifically referenced line 7's compression assembly by its location code, was permanently deleted. Not archived. Not flagged for review. Deleted. This happened while Terrence Banks was being stabilized at the hospital. The machines had been screaming, and someone had spent the night of the explosion making sure the record showed they had been silent. The official incident report was filed on March 17th, 3 days after the event. It described the failure as a sudden mechanical event resulting from normal operational wear, unforeseeable in nature, with no prior indicators of concern identified in the facility's safety management records. It cited a safety inspection conducted at the facility in January, performed by Ridgeline Safety and Compliance LLC, which had found all equipment within operational parameters. It made no reference to the 41 prior safety complaints. It made no reference to the extended service interval on the compression assembly. It made no reference to the pressure irregularity reports, or to Gretchen Hollis's written request for a mandatory review, or to any of the 3 specific flagged entries that Caelum had filed and watched disappear. And it cited Ridgeline Safety and Compliance as an independent third-party inspection firm, a characterization that was, at that time, materially false. Ridgeline had been under a paid consulting contract with the parent company's corporate risk division since 2019 at approximately $80,000 per year, while simultaneously conducting and signing off on facility safety inspections at multiple sites, including Hartwell. This relationship had never been disclosed to the Ohio Bureau of Workers' Compensation, had never been disclosed to OSHA, and was not mentioned anywhere in the January inspection report or in the March 17th incident filing. The report called it an independent inspection. The money said otherwise. Terrence Banks had been in surgery for less than an hour when someone put the finishing touches on that report. Caelum Harte read it in its entirety 3 days after it was filed, sitting at the kitchen table in his house at 2 in the morning, and he has described the experience of reading it as one of the most clarifying moments of his life. Not because it told him anything he did not already suspect, but because it confirmed, in formal language and under official signature, that the people running Hartwell had made a decision. They had decided that what happened on March 14th was going to be what the report said it was, and anyone who said otherwise was going to have to fight every institutional resource those people could bring to bear. Caelum sat at that table until 4 in the morning. He made a list of everything he had. He made a second list of what he still needed. And he started, quietly and methodically, to figure out how to get it. In the days after March 14th, the Hartwell facility's response operated on 2 tracks simultaneously. The visible track was what you would expect: a statement of deep concern for the injured workers, a promise of full internal review, expressed cooperation with the state's initial inquiry, and a facility-wide memo asking all employees to direct any questions or concerns through the appropriate channels. That phrase, appropriate channels, appeared in 7 separate company communications over the 2 weeks following the incident. 7 times. And everyone on that floor understood what it meant, because they had been working in a place where language like that carried a specific weight. It meant, do not talk to journalists. Do not talk to attorneys. Do not talk to regulators who show up asking questions that are not part of a formal process. And above all, do not talk to each other in any form that creates a written record. Not email, not text, nothing that could be saved. On the invisible track, things were moving considerably faster. Ridgeline Safety and Compliance, the same firm that had conducted the January inspection, the same firm with the undisclosed consulting relationship, was contracted to conduct a post-incident inspection of the facility. The inspection was completed on March 26th, 12 days after the event. Dale Ferris conducted the facility tour personally. The Ridgeline inspector spent approximately 4 hours on site. The section of the floor involved in the incident had been repaired and cleaned. The maintenance logs, the modified ones, showed the relevant equipment as having been serviced within the past 30 days. The inspector did not request access to the internal safety complaint log. He was not told what it contained. The post-incident inspection found no ongoing safety violations, made 3 recommendations described as enhancements rather than corrections, and produced a report that was consistent, in every meaningful way, with the report that had preceded it. Clean, compliant, useless. The Ohio Bureau of Workers' Compensation opened a standard review after being notified of the workplace injuries, which was routine. Serious industrial injuries at regulated facilities trigger an automatic process. The review was assigned to a compliance officer named Patricia Sims, who worked out of the BWC's regional office. Caelum had submitted an anonymous concern to the BWC's online safety portal on March 18th, 4 days after the incident, using a personal device at a public library. He had not used his work email. He had not used his home computer. He had been careful in the specific way you learn to be careful when you are a man who has watched safety complaints disappear from a digital system and has stopped believing that anonymity means what the systems claim it means. The concern was acknowledged. A case number was assigned. And then, 2 weeks into the review process, Patricia Sims was reassigned to a different caseload. The stated reason was workload distribution. The Hartwell review was transferred to a newer investigator who had been with the agency for less than a year. The new investigator completed his review of the Hartwell incident in 18 days. His finding: no evidence of systemic safety violations. Equipment failure attributable to normal operational factors. No regulatory action recommended. The report did not reference any prior complaint submissions. It did not reference the service interval extension. It did not mention that the inspection firm cited in the company's incident report had a financial relationship with the company it was certifying. It is not knowable, from the public record, whether the investigator was aware of those things and chose not to address them, or genuinely did not know. What is clear is that the review ended without finding the things that were findable by someone who was looking for them in the documentation that existed. Caelum received the closure notice on a Friday afternoon in late April. He had driven to the BWC's regional office to pick it up in person rather than wait for it in the mail, because he wanted to hold it in his hands. He sat in his car in the parking lot outside that office and read it. 1 page. No acknowledgement of the concern he had submitted. No explanation. Just the conclusion. He sat there for a long time. Then he drove home. He sat at the kitchen table that evening with his son Darius, who was 19 and studying at Columbus State on a schedule that involved a part-time job at a grocery distribution warehouse and loans that Caelum did not like thinking about. Caelum told him everything: what he had found, what he had filed, what had come back, what was going to have to happen next if anything was going to change. Darius listened to all of it without interrupting, the way young men do when they have decided something is serious enough to require their full attention. When Caelum finished, Darius said, "Pop, if you don't do it, who does?" He was 19 years old. He was right. And Caelum sat with that question for 2 days before he made the phone calls that would change the remaining course of everything. Caelum Harte did not go to the press. He did not hire a lawyer that week or the week after. What he did was document. He organized everything chronologically, made copies of his copies, wrote a detailed account of every relevant conversation he had been part of since August, the dates, the settings, the substance of each one, as close to verbatim as memory allowed. He created a paper record that was not housed in any system the company could reach. And then, quietly, using the OSHA federal online complaint system rather than the state office, which had already shown him what it was capable of, he filed a formal whistleblower concern under Section 11(c) of the Occupational Safety and Health Act. The submission was detailed. It referenced specific dates, specific log entries, the modification of the October pressure reading, the deletion of Gretchen Hollis's September complaint, the extended service interval, and the Ridgeline financial relationship. He filed it on May 2nd. He received an automated acknowledgement. He was assigned a case number. He waited. The first sign that something had changed came 7 weeks after the incident. Not a confrontation, nothing that direct, nothing that clumsy. A note in his personnel file. He found out about it only because a human resources coordinator he had known for 8 years told him, standing outside in the parking lot, speaking quietly and not looking directly at him. The note cited concerns about focus and collaborative engagement. It used language that was, Caelum later said, impressively vague, the kind of vague that is a skill that requires craft, because it has to be specific enough to exist in a file and general enough to be impossible to contest. Behavioral concerns. Attitude towards supervisory feedback. Impact on team environment. Nothing that could be grabbed hold of. Nothing that could be answered. Just something sitting in his file that had not been there before, and that would be there for anyone who reviewed it going forward. That was the first one. His OSHA complaint was proceeding slowly. That was not unusual. The agency's whistleblower protection division had been chronically understaffed for years, and the volume of complaints filed with OSHA had been increasing consistently since 2012, up by nearly 3/4 over a 6-year period with no proportional increase in the resources available to investigate them. The backlog was a documented institutional reality, and the company's lawyers knew it as well as Caelum's eventual attorney would. The slowness of the federal process created a window. The company used it. Over the 2 months following the May filing, Caelum's situation at Hartwell deteriorated in a sequence of moves that were individually deniable and collectively precise. Gretchen Hollis left the facility in April, having accepted a position elsewhere. She and Caelum did not say goodbye, and he understood why. She did not want to be associated with what was coming, and she was making the rational choice, and he held nothing against her for it. In late June, 6 weeks after his OSHA submission, Caelum was transferred to a different department. The transfer was framed as a restructuring of the maintenance and compliance function, a reorganization that had been in planning for several months, that was presented as operationally motivated, that had nothing to do with anything. The practical effect was immediate. His new role carried a lower access level in the documentation system. He could no longer pull service records, inspection reports, or the complaint log. The database he had been using for months to cross-reference against the floor reality was now behind a permission threshold he did not hold. He had been moved away from the evidence. He was still employed. He still had his badge. He was just no longer able to see the things he had been seeing. The message was institutional rather than personal, which made it harder to name and harder to fight, and just as effective. Colleagues who had been easy with him for years grew careful. Not unfriendly, careful. The specific careful of people who have been advised, without being told explicitly, that a certain distance is in their professional interest. Caelum learned later from two separate people, who told him independently, that Dale Ferris had spoken to at least 3 of his regular contacts one-on-one, framing Caelum as someone who was going through some personal difficulties and might benefit from some space. Nobody said anything threatening. Nobody said anything that could be quoted back. The message was delivered entirely through implication and social architecture, and it was received, because it always is. Caelum found himself increasingly alone in a place he had worked for 16 years. He ate lunch by himself. He did his shift, he punched his clock, he drove home in the dark. And he kept documenting. He stopped sleeping consistently in late July. He was waking at 3 and 4 in the morning, running through the case in his head, checking the internal logic of his documentation for gaps someone might exploit, replaying conversations word by word looking for the detail he might have missed. His doctor would later describe what he was experiencing as a clinical anxiety response, not a breakdown in the colloquial sense, but a sustained physiological reaction to a sustained threat, one that had no clear edges and no moment of resolution, that operated through bureaucratic process and institutional implication rather than through anything he could confront directly. His blood pressure was elevated. He was having chest pain that turned out not to be cardiac, but was real enough that he went to the emergency room once at 2 in the morning because he could not be sure. He was 47 years old, and he was doing this while working night shifts at a facility where the people who ran it were making his professional life as difficult as they legally could, while he was legally protected from being fired. It was a narrow space to exist in. He existed in it. In August, a second annotation appeared in his personnel file. This one was more specific. It cited a procedural error in a maintenance report Caelum had filed in July. The report had been signed off by his supervisor at the time of submission. It now appeared in his file with a notation suggesting he had failed to follow standard protocol. When he requested the documentation supporting the finding, he was told the record spoke for itself. He contacted an employment attorney for the first time, a woman named Sandra Ochoa, who worked out of a Columbus firm that handled labor and employment cases, and whom he had found through the Government Accountability Project's referral network for workers in exactly his situation. Sandra listened to the full account. She reviewed his documentation, and she said something that Caelum has described as the most clarifying sentence anyone said to him during the entire experience. She told him plainly, "They are building the case for your termination while you are still legally protected. They are manufacturing the paper trail that will make it look inevitable. Stay employed, keep documenting, and do not wait much longer." Sandra Ochoa had been doing this kind of work for 15 years. She had represented clients in 3 prior cases involving the same parent company that owned Hartwell, 2 of which had settled quietly under non-disclosure agreements before they ever became part of the public record, one of which had gone to a federal administrative hearing. In all 3, the pattern had been the same. Internal complaint systems that resolved concerns without corrective action, modified or deleted safety records in the aftermath of incidents, a third-party inspection firm that produced clean reports consistently regardless of floor conditions, and a campaign of targeted professional degradation against the employees who had tried to use the proper channels. When Caelum Harte walked into her office with his documentation, Sandra Ochoa understood within the first hour that she was not looking at one facility's cover-up. She was looking at a corner being added to a pattern she had been tracking for years. She told him that. She also told him that what he had was enough to move, but that there was one piece of evidence that would make the case conclusive rather than arguable, and that she did not yet know if they had it. The piece they were missing was documentary proof that Raymond Colt had been aware of the falsified Ridgeline relationship before the March 14th incident. Not after, not as a defense, but before, as a decision. The rest of the documentation established what had happened and when. This piece would establish who had known it was going to happen and had chosen to let it continue. Sandra believed it existed. The structure of the other documents implied a decision-making chain that had to have a written record somewhere in it. But it was not in any of the files Caelum had access to, and getting to it through formal discovery required a proceeding that had not yet been initiated. They were, for the moment, one document short of the version of the case that left no room for interpretation. Then, on a Thursday morning in late September, Caelum walked out to the parking lot at the end of his shift and found an envelope on his windshield. No name. No return address. Inside was a single printed page. It was the document they had been missing. Someone inside that facility had been watching, and they had made a choice. Sandra filed the formal federal whistleblower complaint with OSHA under Section 11(c). The following week, reinitiated and substantially expanded from the May filing, with the newly obtained document as a central exhibit. The complaint named Raymond Colt and Dale Ferris by role and detailed the pattern of conduct at Hartwell across the prior 14 months. Simultaneously, Sandra made contact with a regional investigative journalist named Calvin Reese, who worked for the Licking County Advocate and had covered labor and industry in Central Ohio for nearly 30 years. Calvin was the kind of reporter who did not move quickly and did not need to be fast. He needed to be right. He spent 9 weeks independently verifying the factual claims in the documentation before he agreed to publish. He reached out to the company for comment in the final 2 weeks of his reporting. He received a statement calling the allegations unfounded and motivated by personal grievance. The story ran on a Tuesday morning in October. It named the parent company. It was factually airtight. By Thursday, it had been picked up by 2 national outlets, and a labor advocacy organization had requested a congressional briefing. By Friday, a paralegal in Indianapolis was calling Sandra Ochoa on behalf of a former employee at the Indiana facility who had heard about the story and had documentation of their own. The company's response was immediate and predictable and fully consistent with everything that had come before. A formal PR statement, a promise of cooperation with any regulatory review, and, behind the scenes simultaneously, a legal motion challenging the validity of Caelum's OSHA complaint on technical procedural grounds. 3 days after the story went national, Caelum's vehicle was broken into in the facility's parking lot. Nothing was taken. The folder of copied documents he kept in the car was examined and left in place. Not a robbery, a message. Sandra filed an emergency protective motion and documented the incident as potential witness intimidation. The second whistleblower from Indiana, who had, by this point, agreed to be represented, was issued a termination notice from his facility within the week. The stated reason was performance and conduct. He had worked there for 11 years without a formal disciplinary record. The system, when it decided to move, moved fast. What followed was 14 months of federal legal process. Discovery motions, document production requests, depositions, continuances, and the specific, grinding exhaustion of fighting an institution with unlimited resources through a mechanism that moves in weeks and months and requires the sustained presence of your full attention at every stage. Caelum remained at Hartwell through most of it. His legal protection under Section 11(c) made termination legally risky for the company, which meant they could not fire him, which meant they were doing everything short of firing him that the existing constraint allowed. His assignments narrowed. His access stayed restricted. His isolation continued. He showed up every night. He punched his clock. He did the work he was assigned. He drove home in the dark, and he documented everything, and he waited for the process to produce what it was supposed to produce. The discovery phase of the federal proceeding changed everything. In responding to a document production request from Sandra Ochoa, the company was required to disclose a complete inventory of its data storage systems. The initial disclosure listed 7 systems. A cross-reference with a timestamp reference in one of the produced documents suggested an 8th. Sandra filed a discovery motion challenging the completeness of the disclosure. The court ordered a forensic audit of the company's full document retention infrastructure. The audit identified the 8th system, an archival backup server maintained by a third-party IT contractor. It had not been listed in the initial disclosure. The company's explanation was that it was a legacy system no longer in active use that had been overlooked. The auditors found it had been accessed as recently as 3 weeks before the discovery request. On it, they found the unmodified version of every record that had been altered or deleted from the primary system, the original pressure readings with Caelum's correct values, the Hollis complaint with its line 7 location code intact, and 51 emails from Dale Ferris's account, sent in the 4 days following March 14th, that had been deleted from the primary system and never disclosed. 47 of those emails were operational. 4 of them were not. Among the 4 was an exchange between Dale Ferris and Raymond Colt. sent at 11:23 in the evening on March 14th, less than 8 hours after the incident. The email documented what Ferris had done in the records room. It confirmed that the records access had been directed. It confirmed that Colt was aware of the Ridgeline relationship and its implications for the facility's regulatory standing. And it contained a passage, the full text of which remains sealed under the terms of the eventual resolution, that Sandra Ochoa has described publicly as the most consequential 12 words she has seen in 15 years of this work. She has said that those 12 words made any claim of ignorance, accident, or reasonable alternative interpretation unavailable to anyone who read them. Caelum Harte read them sitting in Sandra's office on a Monday afternoon, and he sat quietly for a long time after. He has said that he did not feel triumph. He felt something closer to the completion of a long piece of arithmetic, the final number landing where the working had always indicated it would. Raymond Colt's deposition was scheduled for a December Thursday. His legal team filed 2 motions to delay. Both were denied. The deposition took place in a conference room at a Columbus law firm. Colt arrived with 2 attorneys. Sandra Ochoa sat across the table and worked through the documentation chronologically, methodically, document by document, question by question. For the first hour and 40 minutes, Colt was careful and insulated. Short answers, technical deflections, nothing that extended beyond the minimum required response. Then Sandra introduced the email. She placed it on the table in front of him. Raymond Colt read it. He looked at his lead attorney. Something moved between them that everyone in that room saw. Colt requested a recess. The recess was granted. He did not return to the deposition room that afternoon. The following morning, the company's outside counsel called Sandra Ochoa. They were ready to discuss resolution. The deposition had lasted 1 hour and 47 minutes. The recess had lasted the rest of Raymond Colt's willingness to fight. The case was resolved 6 weeks after that phone call. The financial terms are sealed. What is not sealed? The regulatory findings, the federal complaint record, and Caelum Harte's right to speak about what happened to him and what he found. The Ohio Bureau of Workers' Compensation reopened its earlier closure in light of the federal findings and issued a formal adverse finding against the facility. Ridgeline Safety and Compliance lost its certification to conduct occupational safety inspections in Ohio and Indiana, pending a federal review of all prior certifications, which meant that every inspection Ridgeline had signed off on at facilities connected to the parent company was now subject to re-examination. OSHA issued a formal finding of violation against the parent company under Section 11(c), requiring reinstatement, back pay, compensatory damages, and attorney fees. Raymond Colt resigned from his position 4 weeks after the deposition, framed publicly as a voluntary transition. Dale Ferris was demoted to a non-supervisory role. Neither man was criminally charged. Sandra Ochoa, in a public statement following the resolution, described that outcome as a reflection of the significant gap between the scale of the conduct and the criminal enforcement mechanisms currently available for corporate safety violations. She was stating a fact, not an opinion. The gap is real. It has a name in the law, and it is one of the reasons that cases like this one keep happening. Terrence Banks went through 3 surgeries over the year following the incident. The third, performed in the fall, was the most successful. He has partial mobility in his right arm. He will not recover full mobility. The civil action his family brought, separate from Caelum's case, settled under terms that are sealed. He has not spoken publicly about Hartwell. He returned to work in 2023 at a different facility in a role that accommodates his injury. Philip Darden recovered fully and returned to work in a different industry within a year. He and Caelum are in contact occasionally. Gretchen Hollis never returned to industrial compliance work. She is employed in a different field. Caelum does not know all the details of what the past few years have cost her. He thinks about it. Caelum Harte no longer works in industrial compliance. He left the field in the year following the resolution, not because the resolution forced him out, but because the person who came through 14 months of that experience was not the person who had gone in, and that person needed something different. He does volunteer work now through a labor rights organization in Columbus. He helps factory workers understand the protections they are legally entitled to and rarely fully exercise. He answers phones. He helps people fill out OSHA complaint forms. He tells them, before they file, what the system can do and what it cannot, what it will likely cost them and how long it will probably take, and what they will need to have in place before they begin if they want to have a realistic chance of finishing. He tells them the truth. He believes they deserve it before they decide, not after. According to OSHA's own documented data, the number of whistleblower complaints filed with the federal agency increased by nearly 74% between 2012 and 2018. That number has continued to grow in the years since. It is not growing because workplaces are becoming more dangerous. It is growing because workers are becoming more aware of the protections that technically exist and more willing to test whether those protections actually function. In a significant number of cases, they do not function fast enough or fully enough, or without costs that most people cannot absorb. The gap between the legal protection on paper and the practical experience of the person trying to use it is not an accident. It was shaped by the same forces that shaped the culture at Hartwell. And the people who benefit from that gap have an institutional interest in its continued existence that far exceeds the resources of any individual trying to close it. What Caelum Harte had, ultimately, was not a set of qualities different in kind from what most people have. He was not born braver than the 41 workers who filed 41 complaints and watched every one of them disappear. He was not smarter than the people who saw things at Hartwell and decided, rationally, that the price of speaking was more than they could pay. He was a maintenance technician who had spent 16 years catching errors, who had a documentation habit that was already part of his professional reflexes, who had a 19-year-old son who asked him the right question at the right moment. He was someone who had a pink eviction notice in his locker and an inhaler running low and a daughter who ate cereal for dinner without complaining. He was someone who, sitting in a parking lot on a Friday afternoon in late April, holding a one-page letter that told him nothing had been found and nothing would change, made the decision that this was not going to be the last word. The machines at Hartwell had been telling the truth for months before March 14th. They were telling it in the only language they had, and 41 workers had heard it and translated it into the language the system asked for. And the system had taken every one of those translations and marked them resolved and filed them away. Terrence Banks is living with the physical consequence of that system in his body every day. The question that stays, the one that sits in the space between the legal finding and what a man actually lost the use of his arm for, is not why the machines failed. The question is why, when 41 people told 41 different parts of the system that failure was coming, every single one of them was sent back to work and told everything was within acceptable parameters. Caelum Harte found the answer to that question in a backup server that Raymond Colt forgot to mention. The answer was, because every time it happened before, everyone who asked eventually went away. That was the system functioning as intended, until the night it met someone who had run out of reasons to go anywhere. If you are watching this and something in it has landed close to home, if you have seen something in your workplace that did not add up, that was flagged and ignored, that felt like what you just heard, the resources exist. OSHA's federal whistleblower complaint process is free, available at osha.gov, and can be submitted anonymously. The Government Accountability Project and the National Whistleblower Center both maintain support networks for workers at every stage of this process. Legal aid organizations in every state can provide guidance on the options available to you. The system is imperfect. It is slow. It does not always deliver the outcome that the scale of the wrong requires. But it is there. And as Caelum Harte will tell you, the most important thing you can do before you need any of it is the thing he did from the beginning. Write it down. Keep your own record. Start the paper trail before anyone can stop you. The rest comes from there. This has been the story of Caelum Harte, Terrence Banks, and the Hartwell processing plant. Names have been changed or composited to reflect the documented patterns of real cases in this space, including OSHA whistleblower case records, federal complaint filings, and the publicly available investigative record on industrial safety violation and cover-up. The pattern this story describes, the suppressed complaints, the falsified inspection relationships, the systematic retaliation, the backup server that saved everything, is not fiction. It is the anatomy of a real mechanism that operates in real facilities with real people inside them. Caelum Harte got out the other side, not unharmed, but out and talking. And the talking is the point. Thank you for watching. Now share this with someone who needs to hear it.